Court hearing session.
Thank you. Please be seated. All right, we are back on the record on CR 2221-1623. We are going to take up an objection outside of the presence of the jury as it relates to the state's proposed exhibit, in this case, particularly state's proposed exhibit 31. And the court had to go back and review some prior rulings in the case that occurred some time ago. I've done that now, so what I'd like to go through is the proffer and determination if there's still a objection to the exhibit and make a ruling on that outside of the jury's presence. So Mr. Wood has offered exhibit 31, which is a timeline, and Mr. Pryor, does the defense maintain an objection to the admission of that timeline?
Judge, I spoke with Ms. Blake.
I spoke with Ms. Blake, and procedurally, I think at the time that the 404B was filed by the state, we were also dealing with the severance issue, is what I recall. And then she discussed that with me. So I think I may have made a non-objection to the 404B. And I think I made a record of that when Mr. Thomas and Mr. Archibald were objecting to that. So I may forego my objection because I think my recollection is I don't have a record of it, Judge, which is a little unusual, but I think I may have noted on the record to the court that I'm not objecting to the introduction of the 404B evidence.
All right, I understand. I think there was lodged an objection back February 14th of 2023 by you to the 404B motion. Does the state have any clarification on that, Mr. Wood?
Your Honor.
Your Honor, just based on recollection, I believe it was not an objection to all of the state's intended 404B, but to some of it. And my recollection, and I'm not looking at any document, this is just my recollection, was that the defendant did stipulate to some of the 404B, including issues dealing with Charles Ballo and Brandon Boudreaux. That's my recollection.
And Judge, my recollection is that I did file a timely objection, but then at the hearing, there was, and I'm going back, Judge, and we're talking 3 years ago, and I'm just going off of recollection as well, as Mr. Wood is. I believe that I filed an objection, and then at the time of the hearing, I may have orally stated that I'm not objecting to the introduction of the Brandon Boudreaux or the Charles Fallow information, and Mr. Thomas and Mr. Archibald continued theirs, and the hearing was continued on, and somewhere in the interim, Judge, there was a severance order granted, and I don't know whether I was part of the 404B motion. That's where I'm having some difficulty in recollection. My records don't show an order that you granted the 404B in this case, so I don't see an order in this case.
Okay, so just to clarify, there was an objection was filed on behalf of Mr. Daybell by Mr. Pryor, February 14th, 2023 to the 404B. We then had a hearing on the 404B evidence on February 22nd, 2023. The court then issued an oral ruling on the record, and in that oral ruling went through different evidence that was sought to be proffered under 404B. And among the rulings the court made on the court minutes under paragraph 9, specifically referencing consideration of the shooting at Mr. Boudreaux, the court weighed out the 404B arguments and found that it would be admissible at trial. And then in the hearing, I did indicate that I'd gone through the analysis for 404B, looking at the State versus Fox case, doing a two-tiered weighing of the factors, balancing them out with the evidence proffered, and ultimately, and I'm looking at the transcript of this hearing where I made the oral ruling, determining finally, quote, the court does find there is relevance under tier 1, parts 1 and 2 for the introduction of that evidence. And then I looked at rule 403 to see if there was probative value to substantially outweigh the danger of unfair prejudice, and finally determined that as to the attempted shooting of Brandon Boudreaux, there would be more probative than unfairly prejudicial, as it would relate back to the purported plan of the defendants. So the court did find that the state was permitted to introduce that 404B evidence. So as we stand here, knowing procedurally that's the ruling, on the timeline, I guess I'll first come back to this proposed Exhibit 31 and ask if there's any objection at this point for the defense, Mr. Pryor.
No, Judge.
Okay, so Exhibit 31 then has been offered and will be admitted. I would also note on the record that I think the door has been open to discuss that anyway based on opening argument as well. But for that reason, and also based on the court's prior determination made, I am going to permit that reference on 404B evidence. The reason I'm still discussing this for counsel is I think this now triggers a requirement that I give a limiting instruction to the jurors about how 404B evidence is considered. And I do have prepared a limiting instruction that I am going to advise them of at such point as after your exhibit's been offered, Mr. Wood.
Okay.
Okay, thanks for the delay there. We could bring the jurors back in, please. This is,
I don't know where the.
I've got the actual.
And Judge, if I could just quickly inquire before the jury comes back in, if the court did have both pages of that in its,
I don't, I only have first page.
okay, once we get done with this witness, I'll bring that up.
Okay.
All right. Jury is present and accounted for.
All right, thank you. Please be seated. All right, ladies and gentlemen of the jury, apologies for that delay. We were working through an evidence issue. I will note that the state has offered Exhibit 31, which has now been admitted by the court. It's a timeline. It does make some references in there that, for me at this time, I think would be best to give the jurors a special limiting instruction. So I'll read this instruction to the jurors at this time. Ladies and gentlemen, during the course of this trial, evidence will be introduced for the purpose of showing that the defendant committed acts other than for which the defendant is on trial. Such evidence, if believed, is not to be considered by you to prove the defendant's character or that the defendant has a disposition to commit crimes. Rather, such evidence may be considered by you only for the limited purpose of proving the defendant's motive, opportunity, intent, plan, or absence of mistake or accident. So with that instruction provided, Mr. Wood, if you'd like to proceed with that exhibit you missed.
Your Honor, I don't have any.
Well, I believe the witness does.
May I publish?
Yes.
Just briefly before I do, Detective, before we took a break, we spoke about timeline you had prepared.
Correct.
And the reason you prepared that was to aid the jury in understanding the events of this case.
Yes.
If you can take your pointer and go through these events and just read them into the record.
July 11th, 2019, Charles Vallow dies. September 2nd through September 3rd, 2019, Lori, Alex, and the kids, JJ and Tyler, moved to Rexburg, Idaho. The last known proof of life for Tylee was September 8th, 2019. The last known proof of life for JJ was September 22nd, 2019. The attempted shooting at Brenton Boudreaux, Gilbert, Arizona, or attempted homicide, October 2nd, 2019. The attempted shooting of Tammy Daybell, October 9th, 2019. The death of Tammy Daybell, October 19th, 2019.
If you'll continue on the second page.
November 1st, police receive a call about a Jeep. The Jeep was located November 4th, 2019. Chad and Lori get married in Hawaii, November 5th, 2019. Welfare check on JJ, November 26th, 2019, which is the same day Alex and Chad were contacted. The Rexburg Police Department searched Lori and Alex's apartments November 27th, 2019. Search warrant served on the Daybell residence was June 9th on 2020. JJ and Tyler were taken to the Ada County Coroner's office June 10th, 2020. And the autopsy was conducted June 11th of 2020.
Thank you. Your Honor, I have no further questions for this witness at this time.
All right, thank you, Mr. Wood. Mr. Pryor, cross-examination.
Judge, would the court like me to start, or would you, or like to take a break at the lunch break?
Let's go ahead and get started with cross and go till at least then, please.
Good afternoon, all. Good morning, officer.
Good morning, sir.
We do know each other. We've at least exchanged pleasantries a couple of times
Yes, sir.
in the past. And I guess for purposes of this hearing, would you prefer that I refer to you as lieutenant or officer?
Lieutenant's fine.
Mr. Pryor, I apologize very much for the interruption. I wanted to confirm something on that last exhibit. It was entered by the court. Is that a demonstrative exhibit?
That's what I understood.
Either as a demonstrative or a summary.
Okay, thank you, counsel. Apologies for the interruption.
Judge, I'm also looking for the, oh, I found it. So Lieutenant, you've been involved in a number of aspects in regards to this case, is that right?
That's correct.
You've done some investigation on your own in terms of the welfare check with Lori Vallow, is that right?
Yes,
But you've also interviewed a number of witnesses, is that correct?
yes,
You interviewed Melanie Gibb, David Warwick, right?
yes,
Several times?
a few times.
And you've interviewed a number of other witnesses as it relates to this case, is that correct?
Yes,
Okay, now you previously discussed your role as a police officer and investigator in this case. And I guess I want to clarify something if we could, please. As a police officer investigating a case, your role is to conduct an investigation, right? Look at the facts.
correct,
Try to establish and gain some information, right?
correct,
But you're not supposed to judge one way or the other, right? You're supposed to remain neutral,
that's correct,
and you're not supposed to narrow that role as a police officer to a particular person. Is that correct?
that's correct,
In other words, you're supposed to look at the evidence as a whole. And rather than focusing on one person and saying, we're going to assume this person did this, and we're going to build our case around prosecuting that person, that would be inappropriate, wouldn't it?
Correct.
Your role is actually to look at all the evidence, consider all the evidence. And once you've gathered all the evidence that you think is relevant to a case, what do you do with that evidence?
we followed the evidence,
Okay, and then once you follow the evidence, you've established a report or you've come to concluding your investigation, what do you do with that evidence that you've concluded with?
we put a case together,
Okay, and then do you provide it to someone?
we provided to the prosecutors,
Okay, so there's distinct roles as part of a criminal case. You'd agree with that, right?
yes,
And your role is to conduct an investigation, correct?
correct,
Look into all possible evidence of any kind, correct?
that's correct,
And view the evidence, right?
yes,
Not make any determination as to what that evidence means, but rather gather as much evidence as you think is relevant in your mind and put together a compilation of that evidence, correct?
correct,
Okay. And then at that point, only at that point, do you provide it to the prosecuting attorney and they make a determination as to whether or not they will pursue charges against somebody. Do you understand? Is that the way you understand the process is supposed to work?
yes,
Okay. And if you were not to follow that process, if you were not to follow what I just described, that wouldn't be appropriate. There's protocols. You agree with that, right?
yes,
Okay. And you should never blend the roles of a police officer with the role of a prosecuting attorney. You would agree with that, right?
explain what you mean by blend the roles.
Well, I mean, it's not a prosecutor's role to show up at an investigation when you're conducting an investigation and engage in part of the process of interviewing witnesses. You'd agree with that, right?
I've had prosecutors show up to certain investigations.
Okay, but that's not the norm, is it?
I think it depends on the investigation.
Okay, okay. So in other words, you think that it's appropriate that if a prosecutor is deciding whether to pursue charges against somebody, that they should also participate in the interviewing of these witnesses as part of that process. Is that what you're telling me?
I think it's important for a prosecutor to have all the information.
Well, doesn't that create a problem in your mind?
No, sir.
Okay. Well, let me talk to you a little bit about that. Because if you're doing an investigation and you're really remaining neutral as part of that investigation, right? You're not supposed to make judgments, correct?
Correct.
You're supposed to look at the evidence, gather all the evidence, and then make a determination of what evidence you want to submit to a prosecuting attorney, right?
Correct.
Do you ever get involved in the process of deciding whether someone should be charged or not?
What do you mean by that, sir?
Well, after the evidence is all gathered, and after you've done your report as a police officer and put together all of the information, do you ever go over to the prosecutor's office and say, you know what, I put this evidence together, and you know what, I want to have a discussion with you about whether or not we want to charge this person? That wouldn't be appropriate, would it?
I'm gonna object as argumentative.
Sustained.
Okay. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under any circumstances?
And I'm gonna object as argumentative.
I'll overrule that objection.
And could you repeat the question again about?
Yes. But would it be appropriate for a prosecutor to interview witnesses and inject their personal opinion in those processes of interviewing witnesses? Would that be proper under the circumstances?
To interject their personal opinion?
Yeah.
I would say probably not.
Okay. So if you're engaging in name calling or making references to a person's character in a case, that would clearly be an inappropriate act, would it not?
Objection beyond the scope, Your Honor.
That's sustained, and that's facts, not evidence.
Right. Okay. Now, you spoke a little bit about this body cam issue. And you said that it was a policy that there's only one body cam among 7 or 10 of you as detectives. Is that right?
No, sir, I never once said it was policy. I just said there was only one body cam.
Oh, so,
Between 7 detectives.
so in other words, you share a body cam. It's not a policy within the department.
Correct.
Okay, is there a policy in the department about recording or trying to preserve a record when you're interviewing witnesses?
Yes.
Okay, what's that policy, sir?
When we interview and conduct interviews at the police department.
Yeah.
Those interviews are recorded.
Okay. Now, what about if you're out in the field and you're conducting an interview? Is that to be recorded as well?
There's no policy that says it has to be recorded.
Okay. Do you carry a microphone as well, officer, other than a body cam?
No, not on my person, I don't.
Okay. Do you carry a cell phone while you're doing that? That's issued by the county.
Do I keep the cell phone in my car? Yes.
I didn't ask you that. I said, do you carry a cell phone when you go out in the field?
On my person or in my vehicle?
Either one.
In my vehicle.
Okay. And does that cell phone have the technology that allows you to record or photograph and videotape images?
Yes, it does.
Okay. So what I understand is on November 26, 2019, you were directed your folks to go out to the Lori Vallow residence. Is that right?
That's correct.
Okay, and you said that you were with Ron Ball. Is that who you said you were with?
At one time, yes, I was with a couple different officers that day.
Oh, so tell me who you were with on that day. Remind me.
Detective Dave Holt,
Okay,
Detective David Stubbs,
okay.
and Lieutenant Ron Ball.
So there were 4 of you who went out there to locate or to find out some information about what again? Remind me.
About the whereabouts of JJ Vallow.
Okay, and this was a concern that you had because you were contacted by another law enforcement agency expressing concern about the safety of a young child, right?
No, sir.
Okay, tell me what was the purpose?
It was a simple welfare check.
Okay. And you went out on this welfare check and there were, if my map is correct, please correct me. Did all 4 of you detectives and lieutenants go out at the same time?
No, sir.
You went out at different times.
Myself and Dave Holt went out initially.
Okay, and then when did the other 2 officers show up?
When I called them based on the lies that I had been told.
Okay. And these lies that you've been told, at that point, you and Detective Hope, neither of you decided to bring a video camera, right?
That's correct.
And neither of you decided to wear a recorder to record any of the incidents that took place about these so-called lies, right?
That's correct.
And nobody took out their phone and recorded it or made a video or audio recording of the discussion with Mr. Daybell or Mr. Cox on November 26, 2019, right?
That's correct.
And even after you said these so-called lies, even after you discovered that, Mr. Daybell apparently told you something that you didn't think was true, at that point, did you instruct any of the officers who were coming to aid you? Maybe it's a good idea we should bring an audio with, or a video camera with us, or a mic to record some of these statements, because I have some concerns. Did you think
That's
about
not
that?
information.
We did that, sir.
Hold on.
Okay,
I'm going with that. There was an objection and sustaining the objection. So, strike the answer. You can ask another question, Mr. Pryor.
and it was Detective Stubbs who had the video cam, is that right?
That's correct, sir.
And that was when you video cammed Miss Vallow, about when you had contact eventually with Miss Vallow, is that what the video camera that you're talking about?
I didn't have contact with Ms. Vallow.
Now, I'm a little confused about something. And maybe you can clear this up. You said that you asked Mr. Daybell first about whether he had Lori Vallow's phone number, correct?
No, sir, I didn't contact Mr. Daybell till after I contacted Alex Cox.
Okay. At some point, did you ask for Lori Vallow's phone number from Mr. Daybell?
Yes, I did.
Okay. And at no point did you ever make a threat to him saying you're going to turn this phone number over to us, right?
No, sir.
At no point did any other officer walk up to him and say, if you don't turn this phone number over, you're going to get yourself in a lot of trouble. That never took place to your knowledge, right?
That's correct.
Okay. But then after that, you're saying, at first he said, I'm not going to give you the phone number. And then out of the blue, he decides to give you the phone number.
Objection misstates the facts and evidence.
Okay. Then subsequent to that, he
Hold on,
decides,
Mr. Pryor. When there's an objection, I'm gonna rule on it before you launch into another question. So the objection is sustained.
subsequent to that, he decides to give you the phone number. Is that right?
Can you repeat the question, please?
I'll go back over the analysis here.
Thank you.
Your testimony is that Mr. Daybell refused to give you the phone number at first, correct?
That's correct.
And that was an adamant refusal. He said, no, I don't know what her phone number is, right?
That's correct.
And then without any further prompting by the police officers or any encouragement by law enforcement, he shows back up and gives you the phone number later, right?
Objection is misstating the facts and the
Well,
evidence.
I'm trying to establish the facts, Judge.
The objection's overruled. If the witness has an answer, you may answer.
You say he showed back up. He never left when I originally asked him.
Okay,
I had to ask him twice to get the phone number.
okay. And how much time passed between the first request and the second request?
Roughly a minute.
Okay. So without any prompting by the police, he asked him for the phone number. He denied, and then within 60 seconds, he said, oh, here's the phone number. Is that what your testimony is?
When Detective Hope started walking towards us and I re-asked him again, that's when he gave me the number.
So you had to ask him twice. Is that what you're saying?
That's correct.
Now I'm gonna kind of bounce around a little bit, okay? Please bear with me, okay? You made a comment about supposed paintball guns, and if I misquote your testimony, please correct me, okay? You said something about a supposed paintball gun incident with Tammy Daybell, right?
Yes.
Okay. And then you later on decided that it was the words you used were a shooting. Is that the word you used?
Probably.
Well, you were just here testifying a few minutes ago, and you used the word shooting when Mr. Wood talked to you about that, right?
Yes.
Okay. Now, as part of your investigation, you've had a chance to look at all the evidence, right? In this case, you got access to almost all the evidence in this case,
That's
right?
correct.
And have you gone through all the evidence in this case?
Yes, I have.
Okay, and did you look at evidence of facts and circumstances surrounding the Tammy Daybell incident on October 9th?
Yes.
Okay. And Judge, just bear with me.
Your Honor, if he's gonna be showing evidence digitally, can we put our screen back up?
Yeah.
Not sure I'm gonna be up there, but, okay. Now, I would represent to you that we previously stipulated to the admission of a number of exhibits in this case. And one of the exhibits is exhibit number 16, okay? And the parties that previously exhibited, Judge, we've already moved it, it's already been exhibited. So what I'm gonna do is show you exhibit 16, okay?
And this is one already admitted.
It's already been admitted, Judge, previously. Now, you talked about facts, and you used the word shooting is what you used, right? With Tammy Daybell?
Correct.
And you don't believe that Tammy Daybell was shot at with anything other than a paintball gun, do you?
Objection relevance.
Overruled.
You don't believe that Tammy Daybell was shot with anything other than a paintball gun, do you?
Yes, I do, sir.
Okay, and what do you base that on?
The evidence through our investigation.
Okay, and part of your investigation is did you look at the Tammy Daybell evidence that she provided to your office?
My office or Fremont County?
Fremont County.
I did.
Okay. And one of the pieces of evidence is exhibit number 16. Judge, I don't see it going up.
All right, counsel, if you'd like, we can take a lunch break or we can keep moving on here for a minute.
Here we are, Judge.
Okay.
Okay, and officer, I'd have you turn to the screen and see if you can read the screen. Just read it. Not out loud, just to yourself. Let me know when you're done.
I'm done, sir.
Okay. And I would represent to you that this is a email from Tammy Daybell to her friends in the Salem Third Ward of her church. Okay? And would you start with the word something and read the email to me?
Something really weird just happened. I want you to know so you can watch out. I'd gotten home and parked in our front driveway. As I was getting stuff out of the back seat, a guy wearing a ski mask suddenly standing at the back of my car with a paintball gun. He shot at me several times, although I don't think it was loaded. I yelled for Chad and he ran around the back of the house. I have no idea what his motive was, and he never spoke, even after I asked him several times what he though.
Okay. So, and do you see the date on this email? Just about friends there.
Are we gonna object to this being characterized as an email?
I'll sustain that.
Okay.
I want to clarify, Mr. Farr, what type of communication it is.
Well, it's a communication to the friends of the church, and I think it's a text
I'm
message.
sorry.
I can. I believe it's a text message. Judge, I may have misstated that it was an email.
Okay.
My apologies. So this text message went out to all of the friends of the Salem Third Ward. It's an LDS ward over in town of Salem, right?
I can't answer
You
that.
don't know. You know where the town of Salem is, right?
I do.
And that's a town that's close to Rexburg?
Correct.
Okay. And obviously, you can't answer that about the ward or anything like that, but obviously the term ward would suggest that it's some sort of a religious group of folks they're talking to, right?
Correct.
Okay. But this email doesn't say that she was shot with a gun, or there's even a mention of a gun. The email talks about a paintball.
Again, I'm gonna object to characterization of this as an email. It needs to be.
Text message, judge, it's gonna be.
I'm sorry. We'll speak for
Yeah. When there's an objection, Mr. Pryor, again, gotta have time to get it on the record, make a ruling, and then respond, please. So if it's sustained, this states the evidence.
Text.
I'm also gonna object to this being described as a text message. There needs to be some foundation for what this evidence actually is.
Judge, I don't need a foundation. This has been admitted as an exhibit. This is
All right.
it.
I'll overrule that objection. Jury can review it in the format it came in with the screen capture.
So at any rate, this message from Ms. Daybell to the people in the third ward doesn't say that it was a gun, does it?
Does say it's a gun, just says it's a paintball gun.
Oh, it says it's a paintball gun. You're right. Okay.
Yes, sir.
It doesn't say any other gun, though, right? That there's any confusion about that, right?
Not in this email or text.
Okay. Did you also have an occasion to look at I'll be bringing that up later, but the search engine from Tammy Daybell's account?
No, I did not look at the search engine for Tammy's.
Were you aware that, and I'm gonna hack his name, but one of the officers, Officer K, whatever his name is, Officer K, was provided email, search information that Tammy Daybell engaged in regarding paintball guns in a picture. Were you aware of that?
Objection calls for speculation.
I'm asking whether he's aware of it.
Overruled.
Are you aware of it?
I was aware that he was provided information. I can't tell you exactly what information he was.
Okay, we'll get to that in another day. But did you also listen to the 911 call that was made regarding the paintball incident?
I did.
Okay, and there was no mention of a gun in that 911 call, right?
No,
The mention in the 911 call is that someone took a shot at me or tried to take a shot with a paintball gun, right?
that's correct.
Okay, so the suggestion today that it was a gun is based on your own hunch, right?
No, sir.
Well, do you have the gun?
I have evidence of Google searches done by Alex Cox around that time.
Okay. Do you have information as to where Alex Cox was at the time of this alleged shooting?
Yes, sir.
You do have evidence of that?
He was at the Daybell residence earlier that day.
I didn't ask you on the day of the Daybell residence, at the time of this shooting, and do you recall when this shooting took place?
I believe it was maybe 8 in the evening, maybe.
Right. And let's clarify this, because the data that you have regarding him being at the residence was much earlier in the day, right?
That's correct.
And you don't have any data that shows that Alex Cox's phone dinged or any other communication device that Alex Cox had was at the location of the house at the time of this paintball incident, do you?
At the time, no, sir.
Okay. And so at this point, the information you're talking about is there's some Google searches by Alex Cox, correct?
That's correct.
And the information is that you've decided to not take into consideration Tammy Daybell's own statement about a paintball gun?
Objection misstates his testimony.
Sustained.
So what other information are you leaning on to suggest that this was anything but a paintball gun?
The Google searches performed by Alex Cox talked about shooting through Dodge Dakota.
Okay. And I appreciate that. And that would be one of Chad and Tammy Daybell's vehicles. Is that correct?
That's correct.
Okay. Were you aware of who was driving the Dodge Dakota at the time that incident took place?
No, sir.
Okay. Did you talk to any of the family members, any of the 4 children about who was actually the driver of this Dodge Dakota that Alex Cox was trying to figure out a way to shoot through?
We attempted to contact those children and they wouldn't speak with us.
Okay, so you don't know whether Chad Daybell or Tammy Daybell were driving that Dodge Dakota, right?
That's correct.
So the reality is that, Tammy Daybell was driving the Dodge Dakota. It sounds like Alex Cox had something for Tammy Daybell. Is that what you're suggesting?
I'm not suggesting that. I'm just simply stating what Mr. Cox's Google searches were around the time of that shooting.
Okay, and you're basing those Google searches on your position that you believe this was a shooting, right?
That's correct.
Okay, so if Chad Daybell was driving the Dodge Dakota during this time, and he was the primary driver and maybe the only driver, would that mean then you would be looking at whether Alex Cox was trying to shoot Chad Daybell?
Chad Daybell didn't call in a 911 call and said he was shot at. Tammy Daybell.
Yeah, but Tammy Daybell called in a 911 call about a paintball gun. And it was a paintball gun. And we'll have Officer Cannon talk about that. And we'll listen to the 911 call.
Objection, that's not a question.
Well, the question is,
Mr. Pryor, again, you've got to give me an opportunity to rule an objection. If it is sustained, let's just argue it's not a question. You can ask another question.
the shooting and the call that's taken place was in reference to a paintball gun incident, wasn't it?
Can you repeat the question, sir? I couldn't hear you.
The call that was made regarding this incident was a 911 call about a paintball incident, wasn't it? They used the words paintball in the 911 call, didn't they?
That's correct.
We'll move on. Okay. Now, we previously talked about, and Judge, I don't know when you want to stop. I've got a ways to go.
I think this probably is a good time for the lunch break, even though so we will take our lunch recess. That will be an hour. We'll plan on coming back on for additional testimony around 10:15 after 1.
All rise, please.
Thank you. Please be seated. Mr. Pryor, you ready to continue with your cross-examination?
Yes, Judge.
Okay, we'll go ahead and have the jurors brought in.
Mr. Judge, would you prefer I wait?
It's up to you. You can go take the podium if you'd like, or you can wait at council table.
All rise, please. The jury is present and counsel.
Thank you. Please be seated. All right, we are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The defense is conducting cross-examination of the witness, Detective Hermosillo. Mr. Pryor, if you'd like to continue, you may.
Officer Hermosillo, I'm going to take my time. I had probably a little too much coffee this morning, so I waited that over the lunch hour, and now I think I'm okay. Let's hope so. I think the judges admonished me enough at this point that I think I got the point. So we're going to go a little slower if you don't mind. Yeah. So I want to go back to the paintball incident. And you said that one of the pieces of evidence was that Alex Cox had Googled a black Dodge Dakota, correct?
He Googled what caliber it would take to shoot through the windshield of Dodge Dakota.
Was it the windshield?
Yes, I believe so.
Okay. Judge, there's previously been an admission of Exhibit 34 by stipulation. That's Homer J. Maximus with a reference to the state as well. And we'll get back to that in a minute, but there was at least a reference at some point that there was going to be trying to find out what kind of caliber it would take to penetrate a Dodge Dakota vehicle, some windshield or otherwise, correct?
Correct.
And you took that as a threat, as a means of saying that's why Alex Cox was trying to kill Tammy Daybell.
That Google search, along with him being at that residence that same day earlier,
Okay,
and the incident involving Tammy Daybell,
okay, okay. Okay, and that's what drew you to that conclusion, is that correct?
that's correct.
Okay. So we don't know who was driving the Dodge Dakota regularly, do we? Because you didn't speak with the kids, is that right?
That's correct.
Okay. And we do know that on the day that you said Chad Daybell, at least you were alleging that Chad Daybell fled on sometime in June 9th. Is that correct?
Objection mistakes the testimony.
Well, try to clarify that. High rate of speed, Chad Daybell left the area. Is that fair?
That's fair.
That's what you're stating, correct?
That's correct.
And in the vehicle that he was in, do you know that that was the Dodge Dakota that supposedly he was fleeing in?
It was not Dodge Dakota he was fleeing in.
Okay, what vehicle was he fleeing in?
I can't recall off the top of my head. We have it in impound, but it wasn't the Dodge Dakota.
Okay. Okay. So there were two vehicles, an Equinox and a Dodge Dakota.
Which day, sir?
On June 9th, there are two vehicles that the Daybells owned, the Equinox and the Dodge Dakota. So which one was it that he was allegedly fleeing?
I just stated I couldn't recall the vehicle that
Okay.
was arrested.
Okay, okay, that's fair, that's fair. So, just to recap, we know that there was a Google search by Alex Cox on his Homer J. Maximus account, correct?
Correct.
And that there was an allegation that someone was, or that Alex Cox was trying to figure out what type of caliber to at least shoot at a black Dodge Dakota, correct?
Correct.
Okay. We don't know who the target was, or who the target was in that Dodge Dakota, but we know it was someone who owned the vehicle, obviously, right?
Well, I would assume so.
Okay, okay. Now, that's what you based on the fact that you thought that there was an attempt on Tammy Daybell that day, correct?
Correct.
Okay. Now, when you read that email from the Homer J, or the research from the Homer J. Maximus account, did you take into consideration the date of when that search took place?
I did.
And when was that?
I can't recall. I have to refer to my notes.
Okay. I'm gonna take the liberty of helping you out a little bit. At least I think I'm gonna help you out. There. Judge, I don't know why it's not going up on the screen.
Is this a exhibit?
34.
34, sorry, which 34 has sub exhibits, is
I
that
believe it's A, Judge.
34A is admitted previously by stipulation, 34A is what you're trying to publish, Mr. Clark.
Yes, Judge.
I don't know if there's one can assist to see if the okay, it is admitted.
There we go. I'm sorry, and I don't know what. All the best laid plans to prepare for this. So I'd like you to take a look up at the screen, if you would. Look at the date of when this search took place.
Okay.
And what is that date?
October 12th,
Of,
2019.
okay, now what was the date that allegedly Tammy Daybell was shot at with a paintball gun?
October 9th, 2019.
So if I understand, the incident with the paintball gun took place 3 days before this search took place.
Correct.
Okay, but you still continue to believe that was the basis for someone going after Tammy Daybell, is that right?
That's correct.
Okay, all right. But you don't have any Google searches that suggest anything else in a threatening manner? This is the one and only that you're relying on, is that right?
No, that's not right.
All right, what else are you relying on?
If you scroll up on October 9th, I believe that evening,
Okay. Go ahead.
Alex Cox Googles how to make an AR-15 function in cold weather.
Okay.
There's some other Googles if you'd like to pull it up.
Well, I've got those and we're gonna go through those. And we'll have an opportunity to do that, but,
And that was the night Tammy was shot at.
okay. And he Googled that night, right?
That's correct.
What time of night was that, do you recall?
I'd have to look at my notes.
Okay. Okay, but he also had a habit of Googling a lot of things, right?
I can't answer that.
Well, you know about the Hannibal Lecter thing, right?
No, sir.
Oh, okay. Well, before we get to the Hannibal Lecter thing, let's talk a little bit about some of the other searches from Homer J. Maximus. October 21. Best tactical cutting knives, right?
Correct.
See that one?
All right, and Mr. Pryor, you are gonna have to stay by that microphone or we don't pick up what you said.
Okay, Judge. October 22nd, 2019. Sharpening swords. Knife sharpener, right?
Correct.
Okay, what was the date of Tammy Daybell's death?
October 19th, 2019.
Okay, so 3 days after Tammy Daybell dies, Alex Cox is still looking at sharpening swords and a block knife sharpener 3 days after Tammy Daybell's death. Is that right?
Correct.
Okay. October 23rd. 4 days after Tammy Daybell's died. 15 facts about the silence of the lambs you didn't know. Call that one?
No, sir.
Okay. And that was 4 days after Tammy dies, right?
That's correct.
Okay. Now, when you searched, and I believe it was 107, was that the unit that we found all of the knives and the guns?
No, sir, that was 175.
Okay, 175, that was Lori Vallow's unit then, right?
That was the unit that Lori Vallow lived in, but Alex Cox was on the tenant agreement.
Okay, okay. And your testimony previously, I believe that was a day or so ago, there were a significant number of weapons found, right?
That's correct.
Did you do a check on all of those weapons to see who they belonged to?
I personally did not do a check on all those weapons.
What about the knives or the ammunition? Did you check and see who those belonged to?
I'm not quite sure how to check on who the knives
don't either.
belong to.
I don't either. I just asked because are you presuming that the owner of those knives and guns and ammunition is Alex Cox?
They were found amongst his belongings, so I
Okay.
presume that yes.
And we talked about this before, when I was doing some voir dire and native objection, that a lot of those items were items, the knives and the ammunition were items that you pulled out of bags and displayed for purposes of, for lack of a better word, staging them for your photo op, right?
That's correct.
Okay, okay. But again, all of the ammunition, all of the weapons, all of the knives, and the ski mask, that was found in Alex Cox's, at or near Alex Cox's belongings, right?
Correct.
So and I don't want you to speculate, but you're presuming that Alex Cox owned all of this, right?
That's correct.
There's no indication that Lori Vallow had several guns and knives and things like that. Is that fair?
That's fair.
Okay. I want to switch gears a little bit. And I want to talk to you a little bit about Charles Vallow. Okay? Okay. And I assume you've been communicating with the folks down in Arizona about all of that. Is that fair?
Yes.
Okay, so you're well versed in the facts as it relates to Charles Vallow, correct?
No, I wouldn't say well versed. I know the basics.
Okay, but are part of the basics to know where the court proceedings are and who was charged with what?
You would have to be more specific.
Okay, and do you know currently who's charged in the death of Charles Vallow?
Yes.
Okay, who is that?
Lori Vallow.
Okay, are you aware that the prosecuting attorney down in Maricopa County issued a
Objection hearsay.
That's the same.
Judge, I'm asking whether he's aware, not whether he,
Well, by the time you say what he's aware of, then all the information's coming through his, so it's sustainable.
okay. Are you aware that Chad Daybell is not charged with anything in Maricopa County relating to Charles Vallow?
Yes, I am.
Okay. Brandon Boudreaux's next. Who's been charged in the allegations against Brandon Boudreaux?
Lori Vallow.
Is there anybody else?
Not that I'm aware of.
Okay, and you're also aware that Chad Daybell has not been charged in the allegations as they relate to Brandon Boudreaux, is that right?
That's right.
Okay. Now, if Alex Cox was still alive, the suggestion seems to be that he would have been charged with both of those offenses. Would that be fair?
Objection calls for speculation.
It's the same.
Okay. Do you have any information as to who killed Charles Vallow?
Yes.
Who do you believe killed Charles Vallow?
Alex Cox.
Okay. Who do you believe took the shot at Brandon Boudreaux?
Alex Cox.
Okay, thank you. Now, did you have the occasion to look into the history of Alex Cox a little bit?
Briefly.
Okay, were you aware of an incident that occurred in, let me get the date right, August 5th of 2007?
You'd have to be more specific about what occurred on that date, sir.
On that date, there was an allegation that there was an assault on a Joseph Ryan.
That's correct.
You're familiar with that, is that right?
Yes.
And in 2007, is there any indication that Chad Daybell knew Lori Vallow in 2007?
Not to my knowledge, no.
Okay. And in that incident, are you aware that Alex Cox committed aggravated assault on Joseph Ryan?
Your Honor, at this point, I'm going to object to relevance.
I think we're outside the scope of what's happening in this case, Mr. Pryor.
Judge, can I approach, please, with counsel?
Sure, outside watch. Judge, all right, but I just wanted to reiterate, we had an objection that was sustained on relevance grounds, and the court confirms that objection, concluding under 403, it's not relevant for purposes of this case.
Judge, based on that ruling, the state would move to strike the question.
All right, no questions stricken on that topic won't be allowed.
I would like to talk to you a little bit about, Chad Daybell's phone, and I'd like you to refresh my recollection. Okay? Yeah. You made mention that on the 26th, when you were, doing the initial, welfare check, you followed up with calls to, Mr. Daybell, is that right?
That's right.
And your testimony was that, you weren't able to get an answer, or the phone was turned off?
Every time we called, it went straight to voicemail, I believe.
Oh, all right. Did you have an opportunity to go through Mr. Daybell's phone records?
I personally have not, no.
So there's no indication that the phone was ever turned off, was there?
I can't testify that I didn't go through his records.
But you can testify that it just went to voicemail.
Correct, I can testify he didn't answer.
Okay. Now, when you searched Lori Vallow's residence, there weren't any clothes in there. In the residence that she had hanging up on hangers, right?
That's correct.
Do you have any information to suggest that she had mailed or shipped her clothes to another location?
No, I don't.
Okay. And then you, at the time you were aware that Mr. Daybell obviously was married to Ms. Vallow at that point, is that correct?
That's correct.
And is it your allegation that Mr. Daybell left on the 26th or 27th and also tried to avoid contact with law enforcement?
I can't answer why Mr. Daybell left. All I can answer to is I wasn't able to get a hold of him after that date.
Okay, and after that date, did you happen to check credit cards or phone records or anything like that to try to locate him?
Again, sir, I didn't go through Mr. Daybell's phone records.
Okay. Did you gain any information that Mr. Daybell was going on a vacation around the 26th or 27th of that, the end of the month?
We later learned that Mr. Daybell was in California.
Okay. And later learned that he was in California, and that was about the time of the 28th or 29th of November, is that right?
I'd have to refer to my notes.
Okay. And were you aware?
Sounds right.
Okay. And again, maybe the coffee's still affecting me. I'll try to slow down, okay? But you're also aware that Mr. Daybell on the 28th being at Knott's Berry Farms, right?
Correct.
And that was a family vacation with his kids, correct?
I can't testify to who was there.
Okay, so Mr. Daybell wasn't fleeing. He was on the 26th or 27th of the month when Lori Vallow's closet was empty. Mr. Daybell was on a family vacation.
I can't testify that he wasn't fleeing. I can testify that I knew he was in California at a later date.
Okay. And you know that later date was the end of November, right?
Close to that date, sir, yes.
Okay. And you know that subsequent to that, then he went on a trip to Hawaii after that, right?
Yes, he was in Hawaii after that.
Right. So if I understand the testimony, Mr. Daybell was at some point after the 26th, went on a planned family vacation at Knott's Berry Farms, right?
I can't testify it was a planned family vacation.
Okay, all right, that's okay. And then subsequent to that, he then went to Hawaii on a trip to Hawaii where there was some contact with you folks, correct?
Yeah, we made contact with Mr. Daybell in Hawaii.
Okay. And how is it that you found it out that he was in Hawaii again? Remind me.
Through tips that came in through our hotlines that we had set up and cell phone data.
And this is just a question, I'm kind of curious. Did maybe you just look at plane records?
Are you asking?
Yeah,
if I-
I'm asking, did you guys
I'm
look at?
sorry. I can't.
Oh, I'm sorry.
Yeah.
I was gonna slow down. Go ahead, I'm sorry, sir.
Can you repeat the question, please?
Did at any time, did you just take the initiative to look at plane records?
So each officer was tasked with different things.
Okay,
We did have an officer that looked through finance financial, and I assume he did look through client records and credit cards.
Okay, and, if Mr. Daybell was flying on a commercial plane or traveling from Boise to Knott's Berry Farm on a commercial plane, in your experience and knowledge of these things, there would have been a record of that, right?
That's correct.
Okay, all right, thank you. Now, I'm gonna switch gears again a little bit, okay? Please forgive me because I just want to make sure I hit all of these subjects. And before we go there, I want to make sure you did get a subpoena from my office, is that correct? That's correct. And you've acknowledged that you've accepted that, correct? Right. And you were kind enough to contact my office and agree that if I need you to come back, you'll come back at a time that's suitable for both of us. Is that fair?
Yes.
Was there anything else discussed during that phone conversation?
Date said I couldn't make it back.
Okay, and that was because, and we're not going to get into this to let everybody know, because it's nobody else's business, but you have an obligation of some sort, and I've acknowledged that, and we're going to work on that. Is that fair?
Objection relevance.
Sustained.
Okay. Now, as part of your investigation, and I want to be specific to JJ Vallow, okay? The last known sign of life was the 22nd. Is that fair?
The
last time that someone known.
It was September 22nd of 2019.
Right, okay. And the last, at least proof of life for Tylee Ryan was September 8th.
Of 2019.
Of 2019. So I'll do the math in my head if I can. There's 15 days difference between Tylee Ryan and JJ Vallow. Is that correct? For the last proof of living or life, respectively.
Roughly.
15 days. You think JJ died on around the 9th of September, 8th or 9th of September, and Tylee was the 22nd or 23rd. Is that fair?
That's correct.
Okay, thank you. Now, as part of the investigation, you looked into where JJ Vallow was on the 22nd of September, correct?
Correct.
And on the evening of the 22nd of September, he was at Lori Vallow's home.
That's correct.
Okay. And present at that home, staying in that home, were Lori Vallow, correct?
Correct.
At least on the 22nd, JJ Vallow was there, correct?
That's correct.
Melanie Gibb was there, correct?
Correct.
And David Warwick was there.
Correct.
Okay. And on that evening, they were conducting some sort of a religious podcast, the three of them, correct?
Yes, sir.
And the allegation is that JJ was acting up and went into the care of Alex Cox.
Correct.
And then Alex took JJ into a separate apartment, correct?
On which day?
On the 22nd?
He took him to apartment 107, correct?
Right. His apartment or whoever was on the lease for that apartment, right?
That's right.
Okay. And then the last time that anybody saw JJ was later that evening, is that fair?
Yes.
And that was when Alex Cox was carrying JJ Vallow into the apartment of Lori, David, and Melanie Gibb, right?
Correct.
Who were all staying there together, correct?
That's correct.
And then somewhere at that point, whether it was at that point or subsequent to that evening, or that evening, that's when you believe that JJ Vallow was murdered.
That's correct.
Okay. But the next morning, there were three people in the apartment at that time early in the morning, correct?
Objection foundation.
Well, do you know who was in the apartment early that morning on the 23rd?
Hold on, prior, there's an objection, I think that would sustain.
Do you have any knowledge of who was in the apartment on the 23rd of September, the morning of that morning of 2019?
Yes.
And who was there?
David Warwick, Melanie Gibb, and Lori Vallow.
Okay, and at that point, you believe that JJ Vallow was already dead?
I can't testify to the time, but I believe he was killed.
Okay, but then within 2 hours later from that morning, you believe that he was buried on Chad Daybell's property, is that right?
That's correct.
Okay. You had an occasion to talk with Melanie Gibb and David Warwick, is that right?
That's right.
Now, you did it a couple of times, if I recall, one by phone, right? With Melanie Gibb,
Correct.
and that wasn't recorded, was it?
It was recorded
It was recorded?
with her attorney.
No. No, I'm talking about a regular phone call with Melanie Gibb, without an attorney.
I don't remember a phone call.
Okay, all right, we're gonna revisit that maybe at another date, but that's fine. But you also went down to Provo, Utah. And I'm going off of memory, but it was Provo, Utah on the 4th of June of 2020, is that right?
Sure.
Now, at that point, you were interviewing both David Warwick and Melanie Gibb about information they had about these allegations, correct?
Correct.
Okay. And who else was there?
Myself, Lieutenant Ball, and Prosecutor Wood.
Okay, so the prosecuting attorney, Mr. Wood, right there, and a lieutenant that you work with and yourself drove down to Provo, Utah.
Correct.
And was there anybody from any local law enforcement there as well?
No.
Okay, now there was an effort to record that conversation, is that right?
Yes, it was recorded.
Okay, was the entire thing recorded?
I believe the very beginning wasn't. The recorder malfunctioned or something happened that was recorded, but the majority of that interview was recorded.
The majority of it was.
That's correct.
So if I represent to you that there was 22 minutes of recording on that interview, does that sound about the length of what the interview was with Melanie Gibb?
No.
It doesn't?
No.
Okay. Would it be helpful if you were able to listen to that recording and view that recording to refresh your recollection?
Refresh my recollection.
Like about the length of time that recording was?
It should have been longer than 22 minutes. We were
Okay.
there longer than 22 minutes.
How long were you there?
Roughly, say about an hour maybe.
Okay. Now, your testimony is that it should have been longer than 21 or 22 minutes, is that right?
That's correct.
Would it surprise you to learn that, well, you don't know exactly how long that interview took place, though, right?
Yeah, I couldn't tell you the exact time.
And you don't know the length of the recording itself, is that fair?
That's fair.
Okay, and in order to determine that, it would be helpful for you to refresh your recollection by listening to the interview, and it would be able to answer those questions for you. Is that fair?
That's fair.
Your Honor, I'm gonna object beyond the scope.
We're way beyond the scope of your direct counsel if also the officer's going to review that, and I permit it, of course, it's not gonna be in the presence of the jury. So also saying the objection on beyond the scope.
Judge, are you talking about beyond the scope of direct examination?
Yes.
Okay, then officer, we'll revisit that at another time, okay? And we'll leave that for another opportunity when I call you back. Now, on the day that JJ Vallow was found on June 9th, okay? The pictures and the testimony you showed suggested that he was wearing red pajamas. And some Skechers socks, is that right?
That's right.
Okay, do you have a recollection of what JJ Ballo was wearing based on your investigation when he was carried by Alex Cox from Alex Cox's apartment to the upstairs of Lori Vallo's apartment?
Objections, calls for hearsay.
It doesn't necessarily call for hearsay, is wondering what he observed him wearing, if you know, so
Yes,
let's have a roll on that.
tell me if you know the answer.
I don't know the answer to that question.
Okay. Do you know whether or not JJ Vallo was wearing red pajamas when he was carried upstairs by Alex Cox?
Sir, I don't know the answer to that
Okay.
question.
Okay. And Judge, I think at this point, I'm going to save the rest of my questioning for when I call the officer back in my case in chief. That's okay.
Very well. You can do that. That'll conclude the cross-examination then. This time we'll begin with redirect from the state. Mr. Wood.
Your Honor, may I be handed State's Exhibit 31?
Yes.
And State's Exhibit 30. Detective, you testified earlier about when you first met Alec or Chad Daybell.
Correct.
Who was he with?
Alex Cox.
Did he look afraid of Alex Cox?
No.
Alex Cox was Chad Daybell's brother-in-law, correct? When you met him?
That's correct.
Detective, you were asked about your beliefs. Is that fair? In cross-examination, you were asked about your beliefs?
Yes.
Let's talk about your investigation. When you started your investigation, what was the scope of your investigation?
Initially, it was to find the Jeep from Gilbert, Arizona.
And then it expanded, correct?
Correct.
And then what was the scope of your investigation?
To find the whereabouts of JJ and Tylee.
And all this time, you're collecting information from various sources.
That's correct.
Your Honor, may I publish State's Exhibit 31?
Yes.
Detective, you were asked about your beliefs, correct?
That's correct.
And you were asked about your beliefs regarding, I'm going to call it the paintball incident. Is that fair?
Yes.
And when I'm talking about that, to your understanding, what am I referring to?
The attempted shooting of Timmy Daybell.
And you testified you don't believe it was a paintball gun.
That's correct.
So why not?
Through our investigation, we learned that Alex Cox was in the area and on the property of Chad Daybell the morning that Tammy Daybell was shot at October 9th. Through Google searches from Homer J. Maximus, which was Alex's Google account, the night that Tammy Daybell was shot, it was a colder evening. And the Google searches were how to make an AR-15 function in cold weather. And without referring to my notes, can I refer to my notes?
Would it refresh your memory to review your notes?
Yes, sir.
Your Honor, may the witness look at his report.
No objection.
Yes, you can look at it, not to testify from, to refresh your recollections, so once you looked at that, it's down.
On October 8th, the night before we believe Tammy was shot at, Alex is Googling drop yardage from 300 yards to 100 yards, which we assumed when you're shooting a rifle, you're adjusting your sights to your target. That was the night before. The morning of the shooting, Alex was on Mr. Daybell's property. We have him driving up and down the road of Mr. Daybell's property and also on the property. Later that evening into the early morning hours of October 10th is when he Googled how to make your AR-15 function in cold weather. So that's why we believe that it wasn't just a paintball gun. We believe that Alex Cox was there to shoot Tammy Daybell.
Okay. I'm gonna have you look at this timeline. As far as you're aware, these dates are accurate, correct?
I'm sorry.
As far as you're aware, these, in pursuant to your investigation, these dates are accurate, correct?
That's correct.
Did the fact that Tammy Daybell died 10 days after that incident have any bearing on whether or not you believed it was a paintball gun?
Yes.
Did the fact that Chad Daybell got married 17 days later have any bearing on your belief whether or not it was a paintball gun?
Yes.
The fact that there were 2 children buried on Chad Daybell's property have any bearing on whether or not you believed it was a paintball gun?
Yes.
Did the fact that Lori Vallow's husband died within months of these other deaths have any bearing on your belief of whether or not it was a paintball gun?
Absolutely.
And finally, did the fact that Brandon Boudreaux was shot at on October 2nd, 2019, have any bearing on your belief of whether or not it was a paintball gun?
Yes.
And it's your belief that Alex Cox was tied to these events, correct?
That's correct.
And because you were asked about your beliefs, was it your belief that Chad Daybell was tied to these events?
Yes.
Why?
Based on our investigation, the lies that we've been told, the fact that we tried to get a hold of the kids' mother, Lori Vallow, kid's stepfather, Chad Daybell, their uncle, Alex Cox. We weren't able to get a hold of anybody. We were left in the dark. Based on all those events, that's what our beliefs were as collectively.
Pursuant to your investigation, you know when Alex Cox died?
December 12th, 2019.
At any time after Alex Cox died, did Mr. Daybell call the Rexburg police to report that there might be dead children located on his property?
No, he didn't.
Did he call the Rexburg police with any concerns that perhaps his wife had been harmed by someone?
No, he didn't.
Did he call the Rexburg police before Alex Cox died to say he might be in danger?
Judge, we're going beyond the scope. If you want me to, I would ask that I be an opportunity to revisit those issues.
I'm gonna sustain that objection.
Okay.
So
Again, so the first time you met Chad Daybell, what was the first thing you asked him? When you had an opportunity to speak with him?
Asked an answer.
This is a response to the cross, your overruled.
I asked him when the last time he saw JJ Bella was.
And when did he answer?
In October in apartment 107 with Lori Bella.
And did you ask for Lori Bella's phone number?
I did.
And what was his first response?
Judge, this has been asked and answered.
It's in response to the cross.
overruled.
His response was he didn't know her cell phone.
Detective, you were asked a little bit about how you do an investigation. Correct?
Correct.
And we spoke about the scope of your investigation in this case.
Correct.
Is it your testimony that you followed where the evidence took you in this case?
That's correct.
No further questions, Your Honor.
All right, Mr. Wood.
Judge, there were some issues that were opened up. I'd like an opportunity to revisit this.
There were a few, so I'll allow a limited recross, particularly considering your statement, you're going to recall the witness, it'll be limited, but if you'd like to, Mr. Pryor, you may.
Detective, there was some testimony about, I'll wait for you to Thank you. There was some testimony that you had the whereabouts of Alex Cox on the property of Chad Daybell, and that would have been on the 9th
That's correct.
of October.
Yes,
Do you have a recollection of how long he was there on that property?
I don't.
Okay, and you're basing that knowledge on his phone records and his pings, right?
Correct.
Did you have an occasion to look at all of Alex Cox's whereabouts on that day by way of his phone records, or did you just look at that specific time?
We were more interested in that specific time.
Okay, and you, I gather from your testimony that you didn't look at between 8 and 10 o'clock on the 9th when the paintball incident took place. You didn't look at that time for Alex Cox's whereabouts, did you?
If I remember right, I didn't get his location near the property at that time. There was no location.
Okay. And isn't it true, officer, that you didn't get his location at that time because Alex Cox's phone was pinging in Idaho Falls at that time, some several miles away?
I can't testify to that.
Okay. But you know he wasn't on the property by way of his phone ping and all of the metadata. That's the word you used, right? Metadata?
Correct.
By the metadata, Alex Cox wasn't on the Daybell property when Tammy Daybell was shot at with a paintball gun, correct?
No, sir, I can't answer that. I can answer that Alex Cox's cell phone or his device was not on the property.
Okay, and you can also say that his device was on Chad Daybell's property sometime in the morning of the 9th of October, right?
And driving down the roadway in front of the property.
Right. And we don't know who else was on the property on the 9th of October, do we?
I can't testify to who was on the property.
Right. So we don't know if he was there by himself or is he there with other folks, correct?
That's correct.
Okay. And when we're talking about you've been on the Daybell property, right? A couple of times.
Yes.
And you took a photo of the car, and we're gonna revisit that next time we get together. But it's not 100 yards from the end of the Daybell driveway to the road, is it?
No, sir.
Do you have an idea of how long that driveway is? Could you give me an idea if you know?
I couldn't testify to that.
Is it 50 yards?
No, I would say maybe 30, maybe
30 yards?
20, 30 yards. Yeah.
So 60 to 90 feet.
That's my rough guess, yes.
Okay, so if we're looking at a rifle at 300 yards and dropping it down to 100 yards, we don't need 100 yards to get from one end of the Daybell driveway to the other, do we?
What our investigation or our belief was, if you're asking me what my belief is,
No, I'm asking you the distance down the end of the Daybell driveway to the top of the Daybell driveway is that's not 100 yards, right?
well, that's correct.
That's all I have, Judge. Thank you.
Mr. Wood is the state ready to call its next witness.
Your Honor, can we approach?
Yeah.
Your Honor, may this witness leave the stand?
Oh. I didn't know if we are. You want to sidebar first?
No, we're done.
Okay, well, Lieutenant Hermosillo, you may go ahead and return down. And because you are still under subpoena, maybe recall, I will admonish you to abide by the court's exclusionary rule. And you're not permitted to review testimony trial between now and the time you return testimony. If you fail to follow that and follow the trial or observe any testimony, you will not be permitted to testify again. All right. Okay, thank you. right, council, if you'll give me a moment, I want to clarify our record on exhibits admitted through that last witness and make sure the court has a clear record of what came in as it relates to exhibit 34. So we did have a stipulation that on the record here, and for the jurors to know as well, we had, I believe 34 had separate attachments or would be separate exhibits, 34A, B, C, D, and E. Is that what 34 consists of?
Yes, Judge, and the state had stipulated to the admission of all of 34, which included those separate exhibits. They've already been stipulated.
Okay, and understanding they were stipulated to, but still on the record, I'm going to make clear that exhibits 34A, 34B, 34C, 34D, and 34E have all been admitted into the record and are evidence in the case. Does the state concur with that?
That sounds accurate, Your Honor.
Okay. Council, when we conclude, I'll have you stick around for a minute to also see if we need further clarify exhibits on the record. At this time, ladies and gentlemen of the jury and those in attendance, I've discussed scheduling here with counsel. We got this trial started and moving along with jury selection a little quicker than anticipated, and the state is at its stage of putting on its case in chief. They're doing their best to line up witnesses to appear here, coming a little sooner than anticipated. And that's the explanation. We are going to go ahead and conclude for today in order to allow the state to have a full day's worth of evidence and testimony beginning on Monday. And then next week, we should be on a full slate of Monday through Friday trial. Notice also, as I mentioned previously, that tomorrow is not going to be a day of trial. So as I understand it, the state would request that we then conclude trial for the week and commence again on Monday morning. Is that correct?
Yes, Your Honor.
The state, does defense have any objection to that?
No objection, Judge. Thank you.
Okay. So before you leave then, ladies and gentlemen of the jury, this is a pretty long break in between evidence now that you are sworn jurors in the case. And I will again admonish you to please do everything you can to not do anything to learn about the case, investigate the case, look the case up, follow any media in the case. If you do see anything being reported, try to avoid that. Don't talk about the case to anyone else or any of the evidence or facts with anyone, including with each other. You can only do that when you start your deliberations. And when you return on Monday morning, when we'll commence at 8:30 with more evidence, I will be asking the jurors as they return to complete those admonitions and certify under penalty of perjury that you have followed that instruction. So I appreciate you doing that so far. I have confidence you will continue to do that, and thank you for your time and efforts today. That will conclude our trial for today, and we will resume again on Monday with further evidence.
All rise, please.
Thank you. Please be seated. The matter on the exhibit 34 is the court is referencing the defense trial exhibits, and 34 is listed. It says 34A through E, Alex Cox Google searches in October 2019. There's also a 34F and a 34G through J and a 34K through Y. So I just wanted to make clear what came in the record today that will be admitted. We have 34 A through E.
That's correct, Judge. The other ones are yet to come.
Okay,
So, and I'm sorry it was confusing. I tried to do this as plainly as possible and have it all on a thumb drive so that the court can make it easier for the jury, but at this point, it's only A through E. The others have been admitted, Judge. I just haven't referenced them yet.
okay, and just to be clear, even though admitted or and agreed to be admitted by stipulation, for this record to be accurate and for future reference of the record, each time a new exhibit is referenced, it needs to be just called out on the record so the clerk keeps an accurate list of what exhibits have come in and that those track with the actual exhibits. So I think the system works. We just need to make sure that individually, for example, with that, if there's multiple exhibits within a number, then we outline exactly what came in. That way we make sure the jury doesn't see any evidence they weren't supposed to see and they see all the evidence they are supposed to see. So we'll continue to work on that process as we start next week. Before we conclude today, then, is there anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor, thank you.
All right, thanks everyone in attendance today, also for following the court's conduct orders. I appreciate it very much, and we'll be recessed for the day.
All rise, please.